We have a new crop, a new bevy, a new passel, a new group, a new coterie of trial watchers and armchair prosecutors and defense lawyers, especially in view of what's happening regarding Tyler Robinson. And Tyler Robinson is an interesting case because that's a real whodunit. Whodunit. And if you've watched me, I'm telling you right now, there's virtually no evidence whatsoever that he did anything. I mean, not that they can't prove the evidence against him, which they can't, but that he didn't do it. Doesn't make any sense. I mean, nothing. So that's a whodunit / he didn't do it. But the Lindsay Clancy case is really interesting. And for those of you who are fancying yourself as armchair, I guess, prosecutors or prosecutresses, listen to this one. I'm going to take you through this because I'm your law professor today. And we're going to go through this case. This is interesting. Because this, by the way, is what you are charged with knowing. The Lindsay Clancy case. First of all, Fryer. Absolutely fry her. I'll explain why. Not because of what she did, but she has no viable defense. I understand what she's doing, and there are some people that you must know that, and people have a hard time sometimes in the criminal justice world understanding that some people are just evil. Evil, evincing a depravity that we just can't even put into words. None of it makes any sense. A mother with her 3 kids looking your baby in the eye, and I just... Anyway, the Lindsay Clancy case is one of those criminal prosecutions in which virtually nobody disputes what actually happened. What the facts of the case. Who was there, who did it. This involves the insanity defense. And whenever you have these kind of a, sort of an affirmative defense, kind of a, not really affirmative, but so when you have a defense, you have to admit you did it. You can't say, I prove not guilty and NGRI. But it's weird because it's not guilty by reason of insanity. But unlike most not guilties, when you plead not guilty, you're saying, I didn't do it. In NGRI, or not guilty by reason of insanity, you're saying, I didn't do it because I'm crazy, but I did it. See? It's weird. People have a hard time with it. They say, wait a minute, you saying you did? Oh, yeah, she did. She said, I did it, but I was crazy. I didn't know the wrongfulness. We'll get to that in a moment. So this is what this is about. Remember, not guilty normally is, I don't know what you're talking about. I wasn't there. I'm not the guy. This is a different story. So the battle is over why it happened and whether the woman who admittedly killed her 3 children was legally responsible for what she did. And right off the bat, people say, what do you mean legally? What, aliens did it? No, that's not what we're saying. The law says you must have sufficient criminal intent, mens rea, criminal mind, specific intent. There's all kinds of things that you must have. You don't need a PhD in murder, but you must know what you're doing, deliberately intend what you're doing, and anything that interrupts that specific intent, anything can act as a defense. In some cases, when you have a specific intent, cases this, intoxication, voluntary intoxication can serve as a defense. If you were so drunk you didn't know what you were doing, theoretically, not that a jury's going to buy this, but you might want to interpose that. So here are the facts. On January the 24th of 2023, Lindsay Clancy was a 32-year-old labor and delivery nurse. Now think right off the bat, irony. Her job is bringing babies and life into the world, except on this instance regarding her own children. So she is a labor and delivery nurse living with her husband Patrick and their 3 children in Duxbury, Massachusetts. Okay? Cora was 5, Dawson was 3, and Callan was 8 months old. Just think about that just for a moment. Her children. her children that normally mothers feel a bond to and with, that they'll take a life if you dare get in the way. So strong is that bond, that natural, preternatural bond, that connection, that protective streak that you get in front of, and you know it is from just the animal kingdom. Try to affect a woman, the mother of this. Forget it. Anyway, so by the end of that evening, all three children had been strangled. Lindsay had tried to kill herself, apparently, and Patrick Clancy had returned from an ordinary errand to something almost impossible to comprehend. Just imagine just walking in and seeing this. There's the shock and the shock of the shock. Seeing it is shocking enough, but how in 1 second you can go from the most mundane to the most horrific. So horrific, words, ideas cannot explicate it. And you have not lived until you see the crime scene. Until you see that crime scene. Until you see crime scene pictures. And when you bring in the forensics, these are the best photographers in the world. Sometimes black and white, sometimes a color, sometimes mostly both, and also video. And they zoom in to show you the worst of the worst, to show you angles and cuts and gashes and lifeless expressions, and how it has always been said, to the point it's almost cliche. People say this. The children look like they're dolls. That life force, that thing that animates you. You know, when a baby is sleeping, it doesn't lose its animation as a human. It's just sleeping. When a baby has been horribly murdered, it's a different look altogether. And it's something that jurors really have to deal with. And it's very difficult. And then there's this 403 evidence, which is a very interesting piece in the evidence code, which says that evidence sometimes might be probative, might be relevant, but it might be so horrific that it can't be shown. So, in this case, the prosecution says the important events began before Patrick ever even left the house. They will claim, and the facts will show, that Lindsay looked up the driving time between their home and 3V restaurant. Now, let me just give you a little bit of a jump. There was something here called the Mcool rule. It's like this is Massachusetts' version of the McNaughton rule. It's their insanity defense. And what's happening is that you're going to be asking, they're going to be saying whether she knew, whether she was aware of the wrongfulness. We'll talk about this in a moment, the idea that there is something which is problematic, but also something that is so overwhelming, it deprives her of the ability to understand right from wrong. So remember, she doesn't understand right from wrong. She doesn't know. She can't, and she's so labor, she can't stop it. Okay? So he drives between his home and 3V. So she looks up the driving time. She called CVS asking about medication for the children. And she and Patrick had exchanged completely ordinary text messages about dinner. She placed a takeout order. So prosecutors will contend that these mundane acts were actually components of planning, sick, homicidal planning. Their argument is that Lindsay was specifically calculating how long Patrick would be away. So Patrick left at approximately 5:15 p.m. to pick up medicine and food. At 5:32, surveillance footage placed him inside CVS. At 5:33, he called Lindsay and received no answer. She returned the call approximately a minute later. Now think about this. Think about where I'm saying this. Patrick has described that brief conversation as essentially normal, although he later recalled getting the impression that she might have been occupied with something. Remember that. She might have been occupied with something. So he bought the medicine, collected dinner, and then returned home shortly after 6 p.m. So about 45 minutes total. Now, what prosecutors say happened during that relatively short interval in the center of the case is the gravamen of this. Lindsay took the children into the basement. Exercise resistance bands were used to strangle them. When Patrick eventually found Cora, she was face down with a band around her neck. Callan was nearby with another band around his neck. And Patrick searched for Dawson and found him in his basement office, likewise with a band around his neck. Homicide ligature. He removed the bands and desperately attempted CPR. Now, you can't just think for 1 minute. This reminds me of the John Benet Ramsey case, when John Ramsey said how he took his daughter and tried, because even though there's no rational thought. You're looking at this child and you're saying, you can see right away, you can see this child is no longer among the living. But in your heart, you say, you know what, I've heard these cases, I've seen movies, where somebody says, you're not on my watch, and then somehow miraculously somebody's brought to CPR, name it. It's a degree of frantic that words, nothing that I can say, Mr. Eloquent here, nothing can describe this. So before Patrick discovered the children, he found another horrifying scene. Now keep all of this in mind. Lindsay was outside beneath a second-story window, and inside the bedroom there was blood in an open window. She had injured herself and jumped from the house in what the defense describes as a genuine attempt at self-harm for purposes of this. The fall caused catastrophic spinal injuries and left her paralyzed. And prosecutors have challenged whether that attempt should be understood in the same way, in the same manner as the defense portrays it. Because some people are saying she knew right away that jumping wasn't going to kill her. It was like the second floor. She knew that this second story window, that this was an attempt on her part. That this doesn't work. Now, you can argue this, and remember, a lot of this may or may not come from her words. It may come indirectly from others, statements she made to therapists or whatever, non-privileged communications. So what happens right now is interesting. So then Patrick called 911. So the recording itself has become one of the most devastating pieces of evidence heard by the jury. I mean, it will resonate in your mind. Patrick asked Lindsay what she had done and where the children were. Listen to this. She told him they were in the basement. He ran downstairs. Moments later, the dispatcher heard the realization of a father discovering his children in the worst of circumstances. Jurors heard Patrick announce that Lindsay had killed him. Now, during the 2026 trial, Lindsay reportedly broke down while listening to the recording. Cora and Dawson were pronounced dead that night. Callan was transported to a hospital, but died several days later. Now, those are the terrible physical facts. And the legal case becomes considerably more complicated, as you can imagine, after that. So this is going on right now, as we speak. And as you can imagine, everybody is talking about this. And what I want to do is to bring it to your attention so that you know how to handle this. Not from a citizen's point of view. Citizens say, friar. And frankly, I'm not going to necessarily lose any sleep over that, because I happen to believe in vigilantism and certain forms of lynch mobs, certain organized, as as Rachel called it, a colloquial lynch mob. Anyway, so during this trial, Lindsay is going to break down while listening to the recording. Yeah, okay. Now, Cora and Dawson were, of course, pronounced dead that night, and Callan was transported to a hospital again, but died several days later. Now, those are the physical facts. But the legal case becomes considerably more complicated after that. And let me just say right off the bat, I have no problem with a lawyer presenting everything possible under the sun to represent their client. None. The only thing that will be a problem for me, if you must know, is, am I able to pull this off? Will I be able to guarantee to my client, Lindsay, in this case? I wouldn't take the case, but I don't know. Sometimes cases are so, lawyers don't advocate for what you did, but the case sometimes that some people may present something so unique, I would have a hard time because I can't get around that. I just can't get around it because deep down inside I'm thinking this is 100% bullshit. This is bullshit. Postpartum depression, which we'll talk about, does exist. Of course it does. Mental illness exists. But enough to get somebody off of this? No. Anyway, let me proceed. So Lindsay Clancy does not claim that somebody else killed her kids. Her attorneys acknowledge that she caused their death. That's what you have to do. Not guilty by reason of insanity. What you plead is you admit you did it. Her defense, of course, is lack of criminal responsibility because of profound mental illness. Mental illness that never really reared its head before, which we'll find out mental illness that, it's one thing when somebody says, well, he's been in a mental institution their whole life. He had brain trauma, he was shot in the head, he was hurt in the war. Some underlying factual basis that makes you say, well, there's no, here at all, none. All of a sudden, this thing just comes out of the blue. Now remember, when we talk about this, please do not concern yourself with why. Why did she do this? Why would a mother do this? I don't know why. Prosecution doesn't have to explain why. That goes to motivation. That goes to like the hate crime part. Why did you kill these people of color? Why did you kill these gay people? I don't care why. That's the hate crime. I don't care why. The law determines, it cares about intent, criminal intent, mens rea, criminal guilty mind. However, this is different. Anyway, so they contend that she was suffering from postpartum psychosis and bipolar disorder, and that a chaotic series of psychiatric medications and fragmented treatment contribute to a catastrophic deterioration in her mental condition. Okay? Now let me stop right there. And I will try to stop as little as possible. But as you know, in our country, there is a very strong, a valuable group of people who hate big pharma. Loathe the big pharma. You've heard of people talk about SSRIs. You've heard the number of people who have committed crimes using selective serotonin reuptake inhibitors and the like, and the Paxil and Buspar and Prozac, and then came off of that medication. That was oftentimes the course or the causation of the murder itself. Okay, fine. So there is a contingent. Plus, you're going to show that the treatment was shoddy. There were weird interactions. They didn't know what they were doing. I mean, they're throwing the kitchen sink, and it is not per se impossible. It's not like they're saying she was possessed by the devil. Oh, that might be a little bit more difficult. Or she was she was inhabited by somebody from another planet. That might be a little bit more difficult. This is a different story. So there's also considerable evidence, by the way, that Lindsay was, as they say, psychologically unraveling before January 24th. And her family has testified about suicidal thoughts, paranoia, anxiety, and her fear that she might harm the children. Okay? So remember, as you're listening to this, remember, there's the shock and there's the horror. And then once that gets out of the way, if it ever gets out of the way, then you start to say, well, who is this? And you do not know what's going to happen when a jury starts to hear, well, what about this and what about that? And you hear her mother, by the way, her mother testified that Lindsay specifically disclosed thoughts of harming them in December of 2022. Other question you got to ask is, where was the husband? Why did, but this is not something that was new. Now remember, I'm telling you this, and you might say to yourself, well, so what? I have a lot of crazy thoughts too. My beloved mother, not often, but one time we used to laugh. One time she said, I'm going to kill you kids. Never meant it, but perhaps. So parents can go through rage. But this is not a rage. These are children. These are little babies. They're not defiant. And I think we can all stipulate this woman is nuts. She is, I believe the phrase is, batshit crazy. But crazy enough? We'll see. So apparently now then, Lindsay sought, of course, psychiatric treatment. She entered a postpartum program and later admitted herself to a psychiatric hospital around New Year's. Now remember, this changes it a little bit. This is a woman who tried to address it, who tried to do something. Do you think she did this knowing that ultimately this is my defense? I'm going to look like I care now. I don't know. I'm still waiting because, little jump, I like the rather than saying not guilty by reason of insanity, some jurisdictions years ago came up with this verdict called guilty but insane. I like that one. You want to debunk? Okay, you're insane. You're crazy. You're still guilty. You're going to either spend the rest of your life, but you're insane. Let the record reflect. Let there be no doubt she's crazy. But guilty, guilty, guilty. Anyway, then there's evidence she searched online for information about depression and hallucinations and suicidal ideation, and 5 days before the killings, symptoms of postpartum psychosis. She's actively looking at this. She's not just somebody who says, let me see, what can I do? No, this is all verified. This is a person troubled by something. You got to ask the question, and I'm not trying to blame the husband. Where was he? How are you not? Honey, where are you going? Psychiatrist. Why? Oh, I don't know. Honey, why do you keep talking about postpartum psychosis? If that even happened. I don't know. Now, he's not on trial. And as far as I know, as far as any kind of criminal agency statute, I don't know why he would be criminally liable for what? Not intervening? We'll talk about that later, not to get ahead of the game. So her defense maintains that she eventually experienced auditory hallucinations, hearing. This is very interesting. She described hearing a male voice directing her to kill the children and herself. This is very common. And a hospital chaplain testified during the trial that Lindsay later spoke about the voice and initially expressed relief that her children were safe. Now, prosecutors attack that testimony by emphasizing repeatedly that important portions of the alleged conversation were not documented contemporaneously in the chaplain's notes. Okay. And there is the prosecution's problem for the defense. Planning. Let me tell you, just jumping ahead, this is the classic case where it may work, so to speak. And we'll talk about this in a moment. Remember, basically, McNaughton, and I believe it's the Mcool case is the Massachusetts version of this, kind of like the model penal code version of the insanity. But classic case works like this. Guy standing on a subway platform. and he hears the train coming. And there's a woman standing there, elderly woman. And he hears in his voice, push her, you worthless, push her. Do what I say, push her. And he does. That's a little different. It may not work, but at least it was spontaneous. It happened. Whatever. Not to mention his in this particular case, his hypothetical bouts with psychiatric, whatever it is. That's a different story. This built up. This was going on for a long time. This, I don't know what you do, what you're supposed to do, but it's almost like being the wolf man, like lycanthropy, like a werewolf, when you realize I have to lock myself in because that, when the moon comes on, I go crazy. This is a different story. She knew about this. People who are spontaneous, again, each case is different. So prosecutors, as you can imagine, are arguing that psychosis does not explain the calm telephone calls, the restaurant order, the driving time. Boy, that voice really is something. That voice is persuasive, isn't it? That voice probably says, now make sure when you do this, okay, you calm down, call CVS, do this. How about the request that Patrick leave the house and the apparent use of the resulting, this window of privacy? Pretty good, these auditory hallucinations, right? And their theory is brutally simple. Whatever psychological problems Lindsay had, they argue she understood what she was doing and deliberately created the opportunity to do it. Period. Whatever it is. Oh, you hear voices? Okay. Okay. You hear voices? Good. I hear voices too sometimes. I hear music lyrics. I hear sometimes... most of us have had ideations like, I wonder what it would be like to take my boss, but we don't do it. But we thought about it. Maybe you've even heard it. Do you know how many people, this is also kind of a little shout out to schizophrenics. You know how many people hear voices on a regular basis? They do nothing. Nothing. This is different. The defense, of course, answers with an equally fundamental proposition. It's very simple. They will say that a psychotic person does not necessarily appear incoherent every moment of every day. Nice try. Someone could order dinner, use a telephone, perform routine tasks, while simultaneously, they will tell you, inhabiting a profoundly distorted mental reality. A parallel universe that you cannot imagine. They look normal. That's good. And I hate to say it, but what else do you want? So defense psychologist Paul Zeisel has testified that Clancy was severely mentally ill and was not criminally responsible for the killings. That's why they called him. By the way, sometimes, depending upon the jurisdiction, you can say, doctor, yes, how many times have you testified on behalf of the defense? Not this defense, but defense. What? A couple hundred times? Yeah. So you're pretty well known as a defense expert, aren't you? Yeah. And I would imagine you are paid for your services, correct? And is it also true that if you were to continue on in your endeavor as a paid defense psychologist, by the way, remember this old law professor said psychiatry is a joke and psychology is a bad joke. In any event, so if you built a reputation that you couldn't be dependent on, that sometimes you would say, well, I don't know, I think this person is not that crazy. You're not gonna do very well in terms of your employment, your job. So it is incumbent upon you to kind of be known as, call him. He's good. He always puts on a good show, and he'll give you, basically showing that the guy's paid off and he's a defense whore, that which is the underlying, that's called impeachment. Can that be done? Yeah. So, anyway, all of this is why this case can't be fairly reduced to whether Lindsay killed her children. She killed them. She did. That's not the issue. The jury's real and only assignment is, of course, much narrower and much harder to determine. What was happening inside her mind when she did it? If convicted of first-degree murder, Lindsay faces mandatory life imprisonment. There is no death penalty in Massachusetts. If the jury finds her not criminally responsible because of mental illness, NGRI, that doesn't mean she simply walks out of court. She can instead be committed to psychiatric confinement under Massachusetts law. And then, when she gets better, she's released. She's not insane anymore. Remember, she's not guilty. She's acquitted by reason of insanity. When the insanity goes away, her criminal penalty goes away. Now, 3 children are dead. Her children, her babies. And their father had to discover them. It is horrible. Their mother admits killing them. That's not the issue. She survived and will spend the rest of her life carrying, this is what they're saying, both the physical consequences of that night and whatever legal judgment the jury ultimately imposes. So the remaining question is not whether something monstrous happened. Let me just say that again. It's not the issue. The issue is whether the monster in the basement was it criminal intent or was it catastrophic mental disease? And that brings us to the Mcool standard, Mchoul. That's their version of the McNaughton. Mcool. The Mcool standard is Massachusetts' test for lack of criminal responsibility. And it is essentially the Massachusetts insanity defense. And it comes from the case Commonwealth against Mcool, a 1967 Massachusetts Supreme Judicial Court decision that adopted the Model Penal Code, the MPC. The Model Penal Code, I don't want to go into detail, but that's what a lot of states will. A lot of folks say, hey, we like to have our own statutes. Where do we start? Here, we've come up with this. Your legal community, legal academics, it's called the Model Penal Code. It's like the restatements of law and all that stuff. Anyway, so under Mcool, a defendant is not criminally responsible. Listen, if because of a mental disease or defect. Okay? That's number one, because of a mental disease or defect. Number two, the defendant lacked, here we go, substantial. Every time you throw in a word, that becomes part of the defense. Substantial capacity either to appreciate the criminality or wrongfulness of the conduct, or to conform the conduct to the requirements of law. The distinction is critical. Once criminal responsibility is genuinely put in issue, the defendant does not have to prove insanity. The Commonwealth, the prosecution, must prove criminal responsibility beyond a reasonable doubt. The prosecution has to show that Clancy is responsible, basically saying there is no insanity defense. So once you meet that threshold, and really no matter what, before you get angry, that's kind of what happens anyway. So for Lindsay Clancy, that distinction is everything. The question is not simply whether she knew she was killing her children. That's not it, because you can say, yes, she did. The jury can consider whether a qualifying mental disease or defect left her substantially, there we go, not unable, but substantially unable to appreciate the wrongfulness. So I could say, okay, she was not unable, she just wasn't substantially unable. See, every time you put in a word, you give people like me the chance to play with it. The question is whether she was able to appreciate the wrongfulness of what she was doing, or substantially unable to control herself sufficiently. That's the case. That's the case. And that's the battle. And that's the Mcool standard. That's what they have to talk about. So what we have to talk about is this case right now, which is very interesting. Let me explain this. We're coming off of the Tyler Robinson case. That's different. Not only do they have to prove he did it, he was there, it's a big story. This is a different story. They have to prove, in essence, that this is the Commonwealth prosecution, that she was not unable to comport. Let me give you an example of something, and maybe you can explain. Before you say, oh, this is crazy, what kind of a sick world would it is? Because it is sick. And I, by the way, would have no problem finding her guilty. Absolutely. Absolutely. Because in my mind, the potential for this to absolve somebody deals in a situation I can barely even understand or thinking of happening. But I'll give you an example. Let's say somebody was, this is crazy, all right? Somebody was given anesthesia. And during the course of the anesthesia, this person was absolutely out of their mind, propofol, whatever, but was somnambulating, sleepwalking. And the doctors say, yeah, this person was under the influence of anesthesia, gone, but had enough motor skills or motor ability to shoot somebody, kill somebody, and that's what she did. Okay, maybe. There are other cases too. PTSD. Guy goes to war, comes back, and during a flashback, during this moment, he's in war, and he sees the enemy coming, and he, not only does he not able to comport, he thinks he's someplace else. If I could ever be convinced of that, theoretically, yeah, I could. I think I could. Another situation where I could personally is a woman. A woman is a child. Here's one for you. And my wife's made me very, very aware of this. A woman who has been trafficked or has been the subject of abuse over a period of time. And she doesn't leave. It's another thing too. People say, well, why don't they leave? Why don't they just leave? It's a good question, but a little bit more complicated than you can imagine. Anyway, so she is there one day at her home, and she looks at this guy. She looks at this trafficker, this horrible person, and she says, now's my chance. So she gets up and bludgeons him or shoots him or whatever it is. Cold-blooded. Did she know the difference between right and wrong? Yeah. Of course she did. Did she? Yes. Now, that's more like almost, not guilty by reason of insanity in NGRI. It's more of a defense, kind of like the abused spouse defense. A woman who's just had it. You pushed her. You just pushed her too far. Everybody's got a breaking point. This is from the Bodine song, Runaway. Remember that? Everybody's got a breaking point, so there you are. So it's one of those, I could see that. This case, no. Because here is the thing. If I have a disease, all right? If I have a disease where I know this weird, I have this thing where I'm saying, I have this thought about harming my children, while I am, and I know it's coming. I know it's coming like a reflex. It is my affirmative duty as a parent, as a mother, whatever it is, to get out, to leave, to check myself in, to absent myself, to protect that child before the psychosis sets in. Not to hang around and do your research and talk to people and then come up and say, how'd you go, honey? Well, pretty good. How'd your session go? Well, doctor, this one says that, these ideations of harming our children should pass. I'm on this medication that I'm taking to keep me from harming our children. Once you're put on, it's like having a dog, a wild dog. Did you know a little time out? Did you know at common law, in torts, tort is, of course, civil wrongdoing. Tort is from the Latin word tortius, meaning twisted, like contorted, A tort is a civil wrong versus a crime. A crime is where the government files a charge against you. Civil is, this is people against people. Anyway, There was a time when people always you were not presumed to know that your dog bit. So if you had a dog that bit somebody one time, now you're put on notice. It's the one bite rule. That's it. You're on notice. After that, then you can be held liable. If you put up a sign that said beware of the dog, now you've waived the one bite rule because you're telling people you are aware of its vicious propensities. So along those kind of same lines, you are a woman that says, I know I do this. If I have a violent streak where I hit my wife or I hit my children or I steal stuff and I just sit back and I just study it, I want to go to I want to go to an outreach. I want to learn more about this. Why do I do this? Why do I do this? Why am I responsible for this? Why? I know what's happening. So you are taking credit for whatever happens in the future when you know a priori, or you know ahead of time, that you are going to do something, that you have a tendency, a propensity to hurt or harm your children. So don't tell me later on, it was the damnedest thing, I'm hearing voices. You knew about this. Look at all of these searches. This happened well before. This happened. You knew about this. And you're a doctor. And you also have to ask, this is important also, we get into the issue of, and this is very, very critical, the idea of privilege. Normally a psychiatrist, or anybody for that matter, has an affirmative duty never to reveal in court, or can be compelled to reveal, what you said or what you did before. How do I say this? What you said during the course of this, except if you're going to do something. If I'm a lawyer, if somebody comes to me, if somebody comes to me and says I committed a murder, I can't tell the police, no matter what it is. But if you tell me I'm planning on it, that's a different story. If I'm a psychiatrist and you're telling I'm planning, I've got some very serious. I came very close today in taking out my kids. I came very close. Wait a minute. Hold it. Now we're going to ask, and this is another issue. What about the psychiatrist? And if there is an interaction between some of these medications that can cause people great, that's something to consider maybe later on for maybe perhaps civil liability. But I would absolutely say, I'll tell you right now, she's guilty. And I'm sure you feel bad, or maybe you do, maybe you don't, I don't know. But you have not, put it this way, you have your advance, your state that I'm insane, your initial position on the purposes of the defense, to me makes no sense. I don't really care. And the prosecution, the Commonwealth, has met its burden and has proven beyond a reasonable doubt she's fine. You don't need a PhD to kill somebody. You don't need to be, you can be so crazy, but you know right from wrong. Let me give you an example. There was a case in Florida years ago, right when I was a brand new prosecutor, brand new. And kind of in the system, there was a guy named Billy Ferry. Billy Ferry was this crazy guy, and he walked into a Winn-Dixie store, and he had gasoline in some kind of container. He sprayed gasoline on these people, lit them on fire, and killed some. And it was horrible. People were liquefied. Later on, they found statements that he made about, he wrote a letter complaining about cream cheese, that it was bad or something. I mean, he and they said, okay, he was found guilty. I don't know if he died. I'm not even sure. But the point is, people were saying he's crazy, and they're saying not really. Why? Because he ran away and hid. Why do you run away and hide when you know what you did is wrong? When you know what you did is wrong. That's when you do this. That's the issue. That's when you know something is very wrong. That's when you're in possession of your faculties. I cannot imagine what that jury is going through. When you see these pictures, I can only imagine. And by the way, thank God it's not blood or anything. It's still strangulation. It's horrible, horrible. Think about it. The first baby fighting, and you'd also find there was going to be defense wounds and putting up a fight. After the first one, you don't snap out of this. You don't say, oh my God, what am I doing? Then the second one and the third, different positions. Come on. And here's the thing. This is not a statement of whether mental illness exists. This is not a statement about any of this stuff. This is a matter of somebody saying, you are out of your mind. Maybe you are out of your mind. But the part which is the most important, the part which is the most critical, is that in this case, she must be found guilty. Fry her. Even though she's not going to face a death penalty, fry her. What do you think, my friend? I've got some questions for you coming up. Do you think this woman has any chance? I'm going to read your comments. Your comments are critical. What do you think? What would you do? What would you vote as a juror in this case? This is incredible. It's horrible. And it's such an interesting contrast to that of the Tyler Robinson case. So I ask you right now to weigh in, to think, to ask, to review. I'll put some questions for you in the comment section. I also like you to ask you to like the video, like this terrible video, subscribe to the channel, hit that little bell so you're notified of new videos and the like. Make sure you're subscribed. And more important than that, I want you to comment as you see fit.